Good morning, everyone. Sorry to be a minute late starting, but we were having to wait on a quorum. And the quorum just walked in the door. And since he just now got here, we're going to ask him if he would open us in prayer. Brother Cantrell. Amen. All right, ladies and gentlemen, we have 4 items before us today. All 4 are compensation resolutions that have been brought to the House. Initially, there were 6. We did assign an ad hoc or a special subcommittee to look into all of them, since there were so many of them, and in their work found that 2 of them did not meet the parameters necessary to bring forward for consideration. However, there are 4 that we have before us this morning. We will be taking them up as committee subs, and the first one that we have up will be the committee sub to House Resolution 18. And Representative Hughley, if you would come to the podium and present your resolution.
Good morning. Thank you, Mr. Chairman, and ladies and gentlemen of the committee. I guess I'm the only lady here, but gentlemen of the committee. Okay, I need some help back here. Mr. Chairman and members of the committee, I bring to you House Resolution 18 by committee substitute, LC number 345650S. Let me first thank Chairman Perkle and his subcommittee for their careful consideration and their hard work on this matter. H.R. 18 is brought on behalf of Jakeith Robinson, and it is indeed a compensation resolution for wrongful conviction. At the age of 23, Mr. Robinson was indicted along with Leon Tollett, Xavier Womack, for malice murder, felony murder, armed robbery, 2 counts of aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. Mr. Tollett was found guilty of all those charges and sentenced to death. Mr. Robinson was tried separately and was found not guilty on all charges except the armed robbery and the weapons charges, for which the jury was deadlocked. The DA decided to retry the case, and when the case was retried, Mr. Robinson's case was joined with Mr. Womack's case, the 3rd person involved. At the time, Mr. Robinson's attorney objected and requested that his trial continue to be separate because it was going to be prejudicial to put those 2 together. The judge denied the request, but gave them a certificate of interlocutory appeal to the Georgia Court of Appeals, and at the end of the trial, he was found guilty of armed robbery only. Mr. Robinson filed for a new trial motion several times, and then finally, on October 1st of 2001, he filed a direct appeal with the Georgia Court of Appeals, and after waiting some 14 years, that appeal was heard. The court said that we take yet another opportunity to remind the bench and bar that this type of post-conviction pre-appeal delay puts at risk the rights of defendants and crime victims and the validity of convictions obtained after a full trial. It is the duty of all those involved in the criminal justice system, including trial courts and prosecutors, as well as defense counsel and defendants, to ensure that the appropriate post-conviction motions are filed, litigated, and decided without unnecessary delay. That duty, unfortunately, was not fulfilled in this case. So as I stand before you today, Mr. Robinson, as I said, went to jail at age 23. He was released at age 43, and that is the prime of a person's life. It's a time when we start families, when we start our careers, and there is nothing we can do to give him back that time. Mr. Robinson he has 2 children, but they were very small children when he was arrested. So he was not a part of their lives. They're adults now. His father died while he was incarcerated, and he was not able to mourn with the family. And at this particular point, he just wants to have a chance to rebuild his life. And so we ask you to accept the recommendation of the committee, which is $560,000 with an initial lump sum of $50,000, and the $560,000 would be in an annuity over a 20-year period. With that, Mr. Chair, I will yield and answer any questions if there are any.
Okay, Representative Purple.
Thank you, Mr. Chairman. Representative Hughley, and we have talked several times regarding this issue. To be sure, the issue at hand is not the innocence or guilt of Mr. Robinson. Is that correct?
The issue at hand, according to the Court of Appeals, was the fact that he had a right to be heard, an appeal before the Court of Appeals, and that got lost. His paperwork somehow got lost in the system. His case was overturned, but the paperwork, he just got lost. He was sitting out there in prison, and nobody knew what happened to his file.
And if I may follow up, and the Court of Appeals noted I think the quote was staggeringly long, 10.5 years is
Yes.
the verbiage that they used. But Mr. Robinson was, he was put on trial because he was implicated as the getaway driver
Right.
in an armed robbery for a
Armored car.
which the driver was killed.
Right.
And so we're not asserting his innocence. This is a double jeopardy.
Right.
I don't know what I'm not a lawyer, so I don't really know if that's technicality or what, but, Mr. Chairman, but we are not asserting his innocence here. It took a long time for the appeal to be docketed, 10.5 years for it to be docketed. And he was released because of the appeals court said this was a case of double jeopardy. You cannot be tried twice for the same crime, and because initially he was not convicted of, he was acquitted of the murder charge, and was not reached a verdict on the attempted murder or the armed robbery.
The armed
And the
robbery
weapons
and the
charge.
weapons charge was deadlocked.
And so they retried, and then the Court of Appeals ruled that that constituted double jeopardy. So
Right.
for the members of the committee, we're not looking at the innocence of Mr. Robinson. So is that not true?
That is correct. The second trial, when the second trial occurred, the jury was not able to know that he had been tried and had been found not guilty of most of those charges. Right.
You may not be a lawyer, but you were starting to sound like one. Point of clarification, just so everybody understands, the total payment would be $560,000, not $560 plus $50. So it'd be $560 is the total. It would start off with a lump sum payment of $50,000. So then it'd be $510 spread out over the next 20 years. Any other questions? Do we have a motion? Chairman Nix, I'm sorry, I missed your light. There you go.
Yes. Where did this occur?
Columbus,
In Columbus?
unfortunately.
Is there any liability for the local people who actually did this? Should they not be paying something here rather than the state paying it all?
Well, the problem was in the court system. The courts, when his appeal was filed, that went through our courts. And that was after, the police had arrested him and that kind of thing. But it went through the courts. And if the Court of Appeals indicates that the failure was in our judicial system, in the court system.
Okay, thank you, Mr. Chairman.
All right, any other questions? Do we have a motion? Have a motion to pass. Do we have a second? Numerous seconds. All right, we're going to try a voice vote first, and if necessary, we'll do a division of the House. All those in favor, let it be known by saying aye. Aye. All opposed, like sign.
No.
We'll call for division of the House. All those in favor, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Reverse. 1, 2, 3, 4, 5, 6, 7, 8. Vote is 14 to 8 in favor. Motion passes. Next, we have 3 resolutions dealing with 3 gentlemen that were all involved in the same case. Representative Gordon has House Resolution 1038, House Resolution 1039, and House Resolution 1041, working from committee subs LC 345642S, LC 345641S, and LC 345643S. Representative Gordon, if you would come on to the podium, and I'm just going to ask you if you would to, we'll present the entire thing because they're all tied together.
Thank you, Mr. Chairman.
And then we will entertain each as a separate motion.
Sure. Well, thank you, Mr. Chairman. Thank you for members of the committee, gentle ladies, gentlemen, on this day filled with liquid sunshine. I want to also give a special thanks to the subcommittee, its chair and members for accommodating myself and Representative Hughley and Representative Smyrie a week or two ago as we diligently went through these 5 compensation resolutions, and I think the dialogue was fruitful. The questions answered were progressive and got us to where we are right now. So again, I want to extend a special thanks to the subcommittee. Ladies and gentlemen, I bring before you 3 bills that have been introduced to seek compensation for 3 former Army soldiers, Mark Jones, Dominique Lucci, and Kenneth Gardner, who were wrongfully arrested, prosecuted, and subsequently incarcerated in 1992 in Savannah, Georgia, for more than 25 years for a murder that they did not commit. In 2017, the Georgia Supreme Court unanimously overturned these men's convictions based upon the fact that crucial exculpatory evidence was wrongfully withheld from these men's defense. There was also overwhelming evidence that the only eyewitness to the murder was improperly pressured to implicate these men as culprits and was threatened with perjury if he did not change his testimony. Realizing that it would be impossible to gain a conviction of these men, the state dropped all charges against them in 2018. When these men were imprisoned and arrested, they were in their late teens and early 20s. When they were released, they were in their mid to late 40s. As a result, they did not get a chance to attain a dream that they all had since childhood, which was to serve our country by way of the U.S. Army. Subsequently, they did not have a chance to attend a wedding in which one of them was the groom on the night that they were arrested. These men have suffered physical trauma, emotional trauma, a lack of the ability to seek higher education as well as job skills, and have suffered immensely. One is living with his father in Ohio, and the other 2 are currently living in Texas. Committee, we ask that you take the subcommittee's recommendation to award the amount of $1 million each, and it is to be broken up into an annuity, $50,000 paid as a bulk payment, and the rest in perpetuity for the next 20 years.
All right, this screen's a little slow here. Representative Perkle.
Thank you, Mr. Chairman. Mr. Representative, the Appropriations Committee under our chairman takes statutory responsibilities regarding appropriations pretty doggone seriously.
Yes, sir.
And he does do a good job. I pick at him a lot, but privately, never publicly. Again, and I think the record will reflect that we have been good stewards of state resources. In the matters at hand, it is a difficult case, but we must ensure that the empathy that we have for these gentlemen does not trump our statutory responsibility. The Supreme Court, in its decision, did not find that the district attorney withheld this Yamaka report. I think, was that what it's called?
Yamaka statement, Yamaka report.
Yamaka statement regarding, and that's why the conviction was overturned, because that was not given to defense counsel.
Mm-hmm.
And I do have concerns that our quest for state funds through the empathy for these three individuals that is very difficult. The link between withholding of the report was not established that the district attorney or the state had any responsibility in that matter. That, you know, if the police withheld or if it was omitted, but the Supreme Court did not find that the district attorney actually withheld this Yamaka brief or this Yamaka report. And so I would just like to remind members and then ask you a question. It was a long way to get to this question, because the party at hand, the district attorney in your district, in the Savannah district, and the police officers in the Savannah area, there was no link showing that the state had a responsibility, that we abrogated our responsibility or we were the cause of this. So my concern is that in our desire for empathy, that we don't overrule. If we were to deny today or accept this resolution today in this committee, would that preclude these three gentlemen from seeking redress from the locals in Savannah?
That's a good question, Mr. Chairman, and I believe that did come up during the subcommittee hearing. I am uncertain to whether they have a recourse as it relates to Chatham County or the city of Savannah. Everything that you know we talked about, I guess, as it relates to these resolutions was the inappropriate behavior of the assistant district attorney and the fact that the Yamaka report kind of appeared 10 years later and wasn't in initial discovery, and that was through the request of the Innocence Project.
Well, and thank you, Mr. Gordon. If I may follow up, Mr. Chairman, so it was not, the Supreme Court did not find that link that district attorney purposely withheld this, or that, or how it came in the file later. But I think as we looked before, whether we accept pass this resolution or not pass this resolution, the defendants can still, or the gentleman can still seek relief from the locals, I think is what we determined. Is that not right?
If the gentleman,
Okay. Thank you.
Again, I can't remember what the two recourses were as it related to those options at the table. Okay. I know that we just talked about our interpretation of the culpability as it related to the state.
Thank you.
Representative, I want to clarify one thing. You'd said a minute ago, talking about the 50,000 lump sum and then the remainder, $1 million total, so it'd be a remainder of 950,000 to be paid out over a 20-year period.
Yes, sir.
You'd said in perpetuity. I just want to clarify that is
yeah,
not
yeah,
the case.
No, not perpetuity, no, an annuity, I'm sorry. It's not a lifetime payment.
Chairman Hatchett.
Thank you, Mr. Chairman. Representative Gordon, was someone found guilty of this murder? Not these, but was there an individual that was found guilty of murder?
Mr. Representative, that is a question that I'd like to get back to you on a later date. I know that there was a rash of murders in climate as it related to that time period, and these gentlemen were unfortunately victims of I guess a racial sentiment as it related to just a time period in Savannah that drugs and crime and so I'm getting a little emotional, but it was a blemish in the city, excuse me, as it related to crack cocaine and a lot of gang warfare. And I think that they just really were victims of being married to a sentiment rather than.
Chairman Dickey.
Thank you, Mr. Chairman. Vice Chairman Parkle pretty much covered my concerns with it very well, so I won't go into that any deeper. So thank you very much.
Okay. Chairman Watson.
Thank you, Mr. Chairman. Representative, how are these payments determined as far as the
Mr.
number
Chairman, that's
of million? Because the other individual looks like served 20 years and was half as much. So I didn't see the sum on this one, but just curious how we came to that number.
Mr. Chairman, I appreciate that question and thank you for asking. These gentlemen actually had an economist look at what 25 years of their lives would have been monetarily had they finished out their military careers, and that was to not just include salary, but benefits that they were no longer entitled to. And so during the subcommittee, we actually kind of adjudicated that down to the $1 million. It actually started out as $3 million.
Okay. Thank you.
Representative Bonner.
Thank you, Mr. Chairman. I did some due diligence in reading up on the case, and I'm certainly very sympathetic given the situation. I guess what I'm trying to find is what exactly was the failure of the state of Georgia in relation to this? Because it seems to me that in reading it, I just don't see where the state of Georgia would be on the hook for this compensation.
Mr. Representative, that's a great question. And again, our narrative and friendly argument has always been pressure from the DA's office as it related to the Yamacraw report, along with the intimidation against the only eyewitness.
Thank you.
We're probably about to be educated on a lot of things, maybe some things we don't even need to know, but I'm going to call at hazard the calling on Representative Williams.
Mr. Chairman, your generosity is overwhelming. I just wanted to speak to your point. During the period, the Yamacraw report, the Army had taken, because we had so many young military folk that were getting caught up that weren't always involved, the unprecedented step was recommended to put the city of Savannah off limits to military vote. It had just gotten that bad. Having served through basic training in the first station, you tend to go where the action is, and it's usually the worst place to head.
Right.
Representative Hughley.
Thank you, Mr. Chairman.
Isn't it true that the district attorney and the superior courts and all of these courts are agents of the state of Georgia, and they're acting on our behalf? And when somebody is convicted, they're convicted, their case is the state of Georgia versus whatever their name is. And these things are happening because we have laws in this state, and because those laws have been violated, then the state takes on that action. And therefore, isn't it true that that is the only recourse that they have to come to the state? Because your local governments have sovereign immunity, and they can't just go out and sue the state either. This is the only process by which we have for people to seek redress. Isn't that true?
Gentlelady knows what she speaks.
And thank you, Mr. Chairman. In subcommittee, we did talk about the potential to seek redress from the city and from that area. And the attorneys we talked to said that this is not the only way that they have to seek redress, that there was the option to go to the local. And the question that I had was, regarding empathy. It's the citizens in that area that did elect those district attorneys, and but there is additional redress on the local level. Yes, ma'am.
Representative Ridley, did you have a question? Okay. Representative Stovall.
Thank you, Mr. Chairman. To the gentleman, what cost would it be to those ones who've been wrongfully accused to have to go to the city or the local government to seek redress versus them coming before us? And like Representative Hughley mentioned, that all of those are on the behalf of us here at the state. So my concern is, what cost would that come out of their pocket with having to seek redress locally versus what they're doing now on the state level?
I appreciate the question, Ms. Representative, and I would think it would be a cost as it relates to time, which they've already given 25 years. These resolutions by themselves are 2 years in the making. I would imagine that the local government would probably be another 2 years or so, and still have no idea on who would necessarily, advocate for them. Would they have to seek private counsel, and almost really start the process from scratch?
All right, that's all the questions we have. So we will take up each resolution individually. Do I have a motion on House Resolution 1038 to pass by committee substitute using LC 345642S? Have a motion. Do we have a second? Numerous seconds. We will proceed to vote. All those in favor, let it be known by saying aye. Aye. All opposed, like sign. No. I'm going to call for division of the House. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. You get 12. All right. Y'all keep your hands up. Do it one more time. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Reverse. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. All right. That is 12 in favor and 11 opposed. So motion passes. We will now take up House Resolution 1039, LC 345641S. Do I have a motion? Have a motion. Do we have a second? All righty. All those in favor, let it be known by saying aye. Aye. All opposed, like sign. No. All right. Division of the House. All those in favor, let it know, or raise your hand. Reverse. Somebody else showed up on that one. That one passes 13 to 12. Now, House Resolution 1041, Committee Sub using LC 345643S. Do we have a motion? Have a motion. Do we have a second? Have a second. All those in favor, let me know by saying aye. Aye. All opposed, like sign. No. Division of the House. All those in favor, raise your hand. Reverse. Motion passes 13 to 12. These are all now moving out of committee on to the Rules Committee. So Chairman Hughley and Chairman Gordon, you'll need to get with the Rules Chairman to get the paperwork filled out for those, so they'll be available to be asked for in rules and potentially on the floor.
Thank you, Mr. Chairman. Thank you, members of the
Yes, sir. That concludes our meeting. We are adjourned.